Well, good morning, everyone. Thank you so much for joining the U.S.-India Chamber of Commerce's webinar on HR and labor and employment related concerns around COVID-19. Today we have a really insightful and very experienced panel of individuals to help provide you with an overview of the HR landscape as it is today, the new laws that have passed, some considerations for business owners to think about as you're moving forward and making business decisions. And so joining us today, we have Terah Moxley. Terah is a board certified labor and employment lawyer. She is a partner at the law firm Estes, Thorne, and Carr in Dallas, Texas. And Terah will be giving us an overview of the changes in the law that have come down, which may affect many of you in your businesses. And so this is a great opportunity for you to ask any questions in terms of clarification of how the law may be interpreted. I do want to make one note that nothing that is discussed today should be taken as legal advice. We recommend that all of the information you gather today should be used for your consideration in your decisions, but we encourage you to check with your own attorney and with your financial officers, accounting and financial officers to before making any decisions about your business. So we just want to make that that one disclaimer that nothing today should be taken as direct advice for your business. We encourage you to check with your outside counsel on that. Also joining us today, we have FIdel Baca. FIdel is the Chief Marketing Officer and one of the founders of Exponent HR. Exponent HR is an HR technology company, and they have been in business for the last 20 some odd years. And he brings a wealth of HR information to this discussion today. Also joining us is Timothy Thurston. Tim is a financial advisor with Vision Point Advisory Services. Tim works with clients to address employee benefit and retirement plan issues, which as many of you know, have been triggered by some of the changes in the law, but also are considerations for you as you think through some of these decisions. So with that, and without further ado, let me hand it over to Terah. And please note a couple of things about today's call. One, a recording of this call will be made available to all of you and to all of the U.S.-India Chamber members. That recording can be found on the U.S.-India Chamber of Commerce's YouTube channel. And you can find that at YouTube and then at USICOC DFW. Also, if you subscribe to the Chamber's newsletter, links to all of these webinars are also in the newsletter that comes out 2 to 3 times a week these days, along with other helpful information on the constantly changing landscape for businesses. You can subscribe to the newsletter from our website, www.usicoc.org. And also, we hope you will join us for our upcoming calls. We have one on Friday about legal considerations. And then we have another one on Monday with Key Coker, the market president for BBVA for North Texas, who will be giving you a banking update. So with that, let me hand it over to Terah, and then Rachel will take over for Q&A about mid-call. So have those questions ready. You can type them into the Q&A box in the Zoom screen or in the chat box. Terah, it's all yours.
Great, thanks Neil, and I just want to thank you and the Chamber for inviting me to participate. I know that businesses and employers have a lot of questions and things are changing at a rapid pace. So what I'm going to do with my time here at the beginning is give a fairly high-level overview of the Families First Coronavirus Response Act, which the president signed a couple of weeks ago. It was the phase 2 legislation that came through Congress, and it goes into effect today. Before I get into that, though, one thing I'll note is something we all anticipated would be going into effect today was the Dallas paid sick leave ordinance. That is no longer the case. Late Monday night, a judge entered an injunction against the city from being able to enforce that ordinance. So that ordinance is on hold for right now. So if you have taken steps to prepare for today, which was when the city had planned on starting to enforce it, just know that you don't have to comply with that right now. So moving to the Families First Coronavirus Response Act, that law contains 2 main types of leave benefits to employees that employers will need to start offering starting today. So I'm going to start with the emergency paid sick leave that is part of that act. It requires, it covers employers who have fewer than 500 employees, and those employers have to provide up to 80 hours of paid sick leave for full-time employees, and for part-time employees, an amount of leave that is equal to the average number of hours that that employee would work over a 2-week period. So the idea is to give people enough paid leave to cover this 14-day quarantine period that we keep hearing about. Employees are able to immediately use this leave. There is no kind of length of employment requirement or number of hours worked requirement. Starting today, employees of covered employers are able to start using this leave for any one of 6 qualifying reasons. And so I'll go over those quickly. The first one, well, before I get into them, all of these qualifying reasons are premised on an employee's inability to work or telework because of one of these things. So even if an employee is having to stay home to care for a child because the child's school is closed, if the employee is still able to work from home, then they would work from home and you would just pay them their normal wage, and they wouldn't be eligible for this paid sick leave. So remember that everything with respect to these leave benefits has to be tied to an employee's inability to work. So the first reason, and the one that I've been getting the most questions about, is an employee needing this leave to comply with a quarantine or isolation order that's been issued by a federal, state, or local government. The question I have been getting is, do all of these shelter-in-place orders qualify? We have been getting guidance from the Department of Labor and I apologize for my noisy barking coworkers, but we have been getting guidance from the Department of Labor on an almost daily basis since this law was signed a couple of weeks ago. And there is a difference of opinion amongst employment lawyers that I have seen interpreting that guidance and what this first qualifying reason means. I read the guidance to say that these shelter-in-place orders do not count. That these generalized, everybody stay home, stay safe orders don't count. For an example of what would count, I saw, I think on the news yesterday, that there's an apartment complex down in the Woodlands where something like, over a dozen residents have tested positive for COVID-19. So there is a specific quarantine order, a very strict one, in place for the residents of that apartment complex. I think that would qualify as the type of order that would make an employee eligible for this type of leave. And what's important to note here is that there are tax credits that come along with this leave. So an employer is only going to qualify for the tax credits for the leave that is required under the law. So if an employer is being overly cautious in wanting to comply with the leave provisions and grants leave to all of these people who are now sheltering in place, and it turns out that that is not leave that needed to be granted, the employer is probably not going to get tax credits for that. Right before I got on this webinar, I saw that the IRS issued some guidance on this, and I haven't even had a chance to look at that yet. But, this continues to be an evolving situation. One thing that I will say is that the Department of Labor is giving us all a bit of a grace period through about the middle of the month to sort of figure out how all this is going to work. As long as employers are making a good faith attempt to comply with the law, they are not going to face any kind of enforcement action by the Department of Labor. So moving on to the second qualifying reason for this emergency paid sick leave, it's to follow the advice of a healthcare provider to self-quarantine. The third reason is if an employee is experiencing symptoms and is seeking a medical diagnosis. So those first three reasons I categorize as an employee needing leave for self-care, to take care of themselves. And that distinction is going to be important in a minute when I start talking about the caps that the law places on the amount of leave that needs to be paid out. So the fourth reason is an employee needs to care for an individual who is subject to a quarantine or isolation order. That can be any individual. It doesn't have to be a family member. The fifth reason is to care for the employee's child who's under 18 if the child's school or child care provider is closed or unavailable due to COVID-19. And the sixth kind of catch-all reason, which no one quite knows what this means yet, is if the employee is experiencing any other substantially similar condition as specified by the Secretary of Health and Human Services. So I don't anticipate that one will come into play. I think it was sort of just a belts and suspenders type provision that was put in there, but we're mainly focusing on the first five provisions. So I mentioned that there are caps on the amount of leave that must be paid out. So typically the leave must be paid at the employee's regular rate of pay. However, if the employee is taking this emergency paid sick leave to care for someone else, like a family member, or to care for their child because their school is closed, the leave only needs to be paid at 2/3 of the employee's regular rate of pay. And the caps that the law provides for self-care is a maximum of $511 a day, which if the employee takes all 80 hours of leave is capped at $5,110 in the aggregate. And for care for another, the daily leave that must be paid out is capped at $200 a day with a $2,000 aggregate cap. Now I'll quickly talk about the second leave provision that was part of this law, the expansion of the Family Medical Leave Act. This applies to the same types of employers with less than 500 employees. And there is only one single qualifying reason for this expanded FMLA leave, and that is if an employee is unable to work or telework because they have to stay home and care for their child whose school is closed. This covers employees who have been working for the employer for at least 30 days. The first 10 days of this leave can be unpaid, but an employee can elect to use other leave that they have, whether it's leave under an existing employer policy, or if it's this emergency paid sick leave that we just talked about. After that 10 days, an employer must provide paid leave at least 2/3 of the employer's regular rate up to a $2,000 a day cap. A couple of final comments I'll make about these laws. They're only in effect through the end of the year. Employers will need to post notices. Typically, these would, go on the bulletin board in the break room. Since we're all kind of living a work from home life right now, I would recommend that the posting be more virtual, whether you have an intranet or just emailing them out to your employees. The Department of Labor has issued model notices that are available on its website. I believe there are now notices in both English and Spanish. The Department of Labor is also permitting exemptions to businesses with fewer than 50 employees. So that would exempt those employers from having to comply with either one of these leave provisions if compliance with the leave provisions would jeopardize the viability of the business as a going concern. That applies to the family and the FMLA expansion. That exemption only applies to part of the paid sick leave law that is related to an employee needing leave because they have to stay home because their child's school is closed. I anticipate that we're going to get some additional guidance from the Department of Labor on how exactly those exemptions are going to work. One last thought on both of these provisions. It permits employers to exclude healthcare providers and emergency responders from coverage from these leave benefits, and we've gotten some additional guidance on who actually qualifies as healthcare providers and emergency responders. The Department of Labor is currently seeking feedback from the legal community, from the HR community, from business communities on questions they have about this law. So you can go to the Department of Labor's website and give them your feedback. I think they're accepting that until April 10th. They just extended the deadline for that. So that is something that they are going to look at and hopefully consider when they start issuing final regulations that should give us all a lot more clarity. You can also check out the frequently asked questions that are on the Department of Labor's website. I think there's nearly 50 of them now that the department has been issuing kind of in tranches. We got the third tranche over the weekend. So there's additional guidance there. And with that, I'll throw it back to Rachel.
Thank you so much, Terah. We appreciate your comments. We're going to turn it over now to FIdel Baca, who's going to give us some more thoughts on how this affects human resources and what employers should be considering when they're making their decisions.
Thank you, Rachel and Neil. Again, thanks to the Chamber for allowing us the opportunity to bring everybody together and discuss some of these issues. As mentioned earlier, of course, this is all still changing as we read regs and receive new notices each day. And as Terah said, as people address concerns back to the Department of Labor, like any governmental department, will realize that there's certain things that may not have been encountered or thought through. And so things will change. So we always encourage everybody, make sure you're talking with your attorney, make sure you're talking with your tax preparer expert, also looking at the financial impact of decisions you make. So one of the things I want to talk about a little bit is even just starting the process. And we're getting these questions from clients on a regular basis, not as many as I thought we would have had, but people asking questions, again, asking questions of us in a support department for a human capital management platform or a payroll or tax provider. In some ways, it's kind of like asking the receptionist at the law office for guidance rather than speaking to the attorney, because these are decisions that have to be looked at in a holistic view. So for example, people that eliminate employees because they need to cut operating costs because they can't open up a business need to consider whether or not they're in violation of the WARN Act just by releasing so many employees. If they decide not to release employees and they have those employees on site, what percentage of them are still there? Are they at 50 of 100 or 33% of an active workforce, and some of the various rules applied under the WARN Act? If they decide to send people home, how they send people home can make a difference. So we know there's a lot of confusion around terms like furlough, termed, laid off, and some of the language within the Act actually speaks to furloughed type employees and laid off employees and talks about the goal of maintaining those employees on your rolls, but there's other consequences to doing that. Furloughed employees in some cases are eligible for their benefits. They're eligible for retirement plan contributions. In other cases, they're not. So before people make decisions about even terminating employees or keeping employees, they should make sure that they look at the full picture to see what the financial impact is beyond just the health of their employees and the health to their business. One of the other provisions is the paycheck protection elements, which allows you to continue to pay employees on your rolls. And again, as Terah said, this has more to do with people that are unable to work in the workplace as part of an essential service, or people who are unable to work from home. When people are working from home and they're performing their full duties and receiving their full pay, most of the stuff really doesn't apply to them. So we're talking about, what do I do if I have employees that need to be working, but I don't have work for them under the circumstance, and I don't want to terminate or furlough them, but I want to keep them on my employer rolls. So you can do that, and there are SBA loans. I think there's about $350 billion built into the plan to allow you to do that. And when you do that, there's other considerations that go along with that. This is really for compensating employees and keeping them on the rolls, in theory, when they make less than $100,000 a year. And you could do that and pay them with a loan of up to $10 million. And you would do it for 2.5 weeks, and that 2.5 months, but that 2.5 months is calculated based on your prior 12 months income annualized, divided by 12 times 2.5. And you could use money from that $10 million small business loan to pay those people. Now, you can pay that loan back over a 10-year period at either a 0 or no more than a 4% interest rate. I believe the default rate on it right now is 5% or 0.5%. And only a certain percentage of that would be used for payroll, because you'd probably also still be paying rent, utilities, and other things, but only up to 25% of that money in today's regs could be used for paying for those types of things. The other 75% has to be going to paying employees. Now, those loans can be forgiven, but there's a lot of qualifications to that forgiveness. So again, people should read the regs if they're going to take those loans, make sure that they track what they're doing to ensure that they don't violate any of the covenants of the regulations, so that they can receive that forgiveness on those loans. Now, there's a couple of things that we're also seeing where people are hearing that they can get the paybacks on certain elements of the Act, or use it as a credit against taxes. And we're talking about the employer side of Social Security taxes. So again, as they're making decisions and they say, hey, I know I'm supposed to be able to pay these employees, but I need the money to pay them, they can get credits back on their tax return, on their 941 essentially, but they need to consider a couple of things. First of all, they're probably using an outside service, whether it's us or another provider in the industry. And by default, people are going to withdraw those Social Security taxes, the employer side of them, every time they process payrolls. And then at the end of the quarter, they're going to file a return. Well, in normal personal income tax, when you take an extension, you normally still have to put in the money, even though you're going to file the return later. In this case, it's reversed. You can keep the money now, but we still have to file the return. So each quarter, your provider is probably going to file the return. The question is whether or not you had them pull those Social Security tax dollars, the employer portion of them, from your accounts when they process payroll. So people need to look at that and say, if I'm going to use that money for these programs, then I need to track. And part of that tracking is making sure that in your systems, you have the proper coding set up. I know we're getting a lot of questions from clients about coding, and we have a very unique and comprehensive coding system, which is going to allow us to create some special leave type coding, special payment type coding. So that way those clients can track this. And I think that this is going to be true, and Terah, please jump in if I say anything incorrect, but I would suggest that not only do people check with their attorney and their tax accounting firm before they make final decisions, but document what you've done, why you've done it, and what regulation you're reading or interpreting that allowed you to do that. And then make sure that anything that is being processed through, whether it's a payroll system or whether through your AP accounts, that anything you do, you make sure that you have properly documented audit trails, not only to be able to claim the necessary credits, but as a affirmative defense in case you go through an audit. I imagine that in a year or two from now, there's going to be a lot of audits to ensure that people are using dollars in the appropriate ways. So kind of in summary, I would say the first thing is, before you make decisions on firing people or furloughing people or paying people when they're not working, make sure you understand what your costs are going to be and how you're going to be reimbursed for that, whether it's through an SBA loan that'll be forgiven or not forgiven, whether through tax withholdings and how you will apply those in your tax return filing, and then how you will manage the payback elements of those if they apply. And then most importantly, anything you do, document it. Make sound decisions, document the decisions, why you made the decision, when you made the decision, particularly for those elements that are retroactive back to February 15th, to make sure that you have everything in order, not only for today to do it accurately, but for a year or 2 years or 3 years from now in case you go under audit. And I'll turn it back over to anyone.
Well, and just to jump in for a second and to echo that, you know, that is going to be so critical. And I mentioned the IRS guidance that I saw just right before I jumped on the call, and the 2 minutes I was able to spend scanning that, it talked in detail about what documentation is going to be required to claim the tax credits related to these new paid leave laws. So I assume additional guidance is going to be coming out related to the type of documentation you'll need to seek the forgiveness under the SBA loan. So definitely echo what FIdel is saying, that document, and make sure you're consulting with your legal counsel and your accountants on how to make sure that you've protected yourself and how to make sure you're going to be eligible for all the relief that these laws are going to provide.
Thank you.
Well, thank you, FIdel, for those remarks. We're going to turn now to Tim, who's going to talk to us about these circumstances and how they may affect retirement plans, 401k withdrawals, looking towards the future for your employees and retirement.
Thanks, Rachel. We are, as I'm sure many on the call are contemplating, you know, these transactions with their employees. We're speaking with our clients these days about what to do about employer matching contributions. Can we suspend a match? Can we change the timing of those matching contributions? And the answer to that question generally depends on the nature of that employer match. If it's a discretionary match, in other words, it's not hard coded into your plan document, those matches may be discontinued or suspended without notice to your employees. If it's a safe harbor contribution or other kind of hard-coded match, they can be suspended, although there's a notice period that's required, and there are some considerations around discrimination testing for those changes. So the good news here is that employers can make strategic changes with regard to their employer contributions to their 401k or other retirement plans. And I'll echo what others have said. This is an area where you're going to want to visit with your plan's provider, if it's Fidelity or Prudential or Empower, one of those companies. And also, if you have outside ERISA counsel, this would be an area to visit with that person about as well. There are on Friday. Actually, I want to step back. We've talked a lot about reductions in force. A note on that area. the IRS deems a reduction in force it may potentially cause a partial plan termination. The end result of that is that if there's a partial plan termination, folks who are affected by that need to be completely vested in any unvested employer contributions to their retirement plan accounts. The IRS has a deemed threshold at 20% of a company's workforce for those to determine whether or not a partial plan termination has taken place or not. These are facts and circumstances situations, so it would be a good exercise if a company has already gone through a RIF, or if a company is considering a RIF, to visit with your HR staff and visit with your outside providers about whether or not your RIF would constitute a partial plan termination. Lastly, on Friday, the 27th, the President signed into law the CARES Act, which was the Coronavirus Aid, Relief, and Economic Security Act of 2020. This act will require some action by folks who sponsor retirement plans for their employees. There are 4 main retirement plan related provisions. One, the first provision creates a new in-service withdrawal opportunity for folks who are affected by this COVID-19 virus. So a qualified individual would be someone who has whose spouse or dependent has been diagnosed with COVID-19, or they've suffered a adverse financial consequence because of the diagnosis, a furlough, a quarantine, or inability to work. If someone's hours have been reduced or if they've been terminated from their job. So this would allow qualified individuals to take a distribution of up to $100,000 without the 10% tax penalty. It also provides that distribution may be rolled back into the plan within 3 years. And that the taxes that would be due from that distribution would be paid over 3 years as well. The CARES Act also created a new loan for folks who are qualified individuals. They can take up to a loan of up to $100,000 from their retirement plan account, or 100% of their account balance, whichever is higher. And these loans are available immediately. You would need to a company would need to work with their record keeper to implement these provisions into the plan. For folks who are retired, the Congress has waived RMDs for 2020. So if a person's over the age of 70 and a half and is due to take a required minimum distribution, those RMDs have been waived for 2020. And then lastly, and it doesn't usually affect that many folks these days, but if you are sponsoring a defined benefit plan, there's funding relief that would allow you to continue to make lump sum distributions to folks who are eligible for those distributions. We think employers should be doing several things. Obviously, folks need to continue to run their companies and make sure their businesses are still there. We encourage folks to be communicating with your service providers, making sure that you're talking to your plan provider about anything that you're thinking about doing with your plan. I think it's a good practice to be talking to your employees about changes that you're making to your plans, and then evaluating whether or not any amendments are necessary for your plan due to the CARES Act. Lastly, employers, and even in these days, need to continue to administer their plans in line with their plan documents, and make sure that employee contributions and loan repayments, to the extent those are still being made, that those get to the plan on time, so that you're not creating a potential for a prohibited transaction for holding on to those employee deferrals and loan repayments. Rachel?
Thank you, Tim. We appreciate that. At this point in our webinar, we're going to open it up to a Q&A. So if you have questions for our panelists, please go ahead and either type them in the Q&A box, which is at the bottom of your screen, or there is a chat box. You can put your questions in either place, and then I will go ahead and read them to our panelists. Panelists, you can listen to the question and decide amongst yourselves who wants to take which question. Our first question is about having contractors. If we have any contractors and we put them on part-time work hours, will they be able to collect unemployment benefits? That's probably for Terah.
So I know that the unemployment expansion that was included in the CARES Act that was passed, gosh, was it just last week? It seems like much longer ago, does expand some coverage to independent contractors and that type of thing. I'm not quite sure the context of the question, but one thing I'd want to be careful of is if you are going to be changing the nature of the work that the independent contractors do, or kind of changing the relationship between the business and the independent contractor, they might lose that independent contractor designation and be more like an employee, which could, bring with it a whole host of things. So if that is part of what you're considering, I would definitely encourage you to reach out to legal counsel to discuss the parameters around that.
And following on that, we've received several questions around that also. People that have contractors, and again, Terah, correct me if I'm wrong, but I believe a better approach might be, were they ever contractors versus employees to begin with? And don't expose yourself by changing somebody's employment relationship. Contractors today are in a kind of unique situation because contractors in general don't go apply for unemployment. So they're not going to get the unemployment dollars. They're also not your employees, but there are provisions on the small business loan side that talk about paying contractors as well as employees. So while they may not be entitled to some of the leave provisions, the SBA loan, the paycheck protection area, does have provisions in there that include contractors, but I would start with, are they employees or contractors, before I would start making decisions about bringing people back onto roles and considering calling them employees just so they could participate.
Okay, thank you. Our next question is, what is a furlough versus a layoff from the CARE Act and an SBA forgiveness point of view?
I'll take a crack at that one. And again, anyone please feel free to jump in. But essentially, when you use the term furlough, you're talking about essentially sending somebody home without pay, but for a defined period of time, which usually doesn't extend beyond 6 months. And you'll see that reference to 6-month periods on several things within the legislation. But it's basically sending somebody home for a short and defined period of time upon which you're not paying them because they are on a type of unpaid furlough, but you may be required to continue to offer them benefits. You may, and again, this would be more for Tim, whether or not those furloughed employees still participate in retirement plan activities and matching and things like that. Would that be your correct definition of it, Terah?
Yeah, for sure. So, I mean, one thing that I've been telling people is at its most basic level, furloughing an employee is, they are still considered your employee. You might not be paying them and they might not be performing work for you, but they are still considered to be on your, payroll, versus terminating someone where you sever that relationship. With respect to the CARES Act specifically, part of the forgiveness that is available there for loans that are taken out under the Payroll Protection Act, there is a formula by which the amount of the loan that is going to be forgiven can be reduced if you have eliminated the number of employees you have, or if you've reduced their salary. I'm not quite clear yet on whether or not it's going to take into account whether or not you have reduced people's hours by furloughing them. And then one more thing I'll throw out there is for people who are considering furloughing employees, I have clients who have been doing that sort of 1 week on, 1 week off, or 2 weeks at a time. You'll want to pay careful attention to your employees who are exempt versus non-exempt. For those exempt employees, you'll want to make sure that you furlough them in work week increments. Because if you furlough them just a couple days at a time, under the Fair Labor Standards Act, those employees would still be eligible for their full week's wage. So obviously, if you're furloughing people for cost-saving measures, you want to make sure you don't fall into that trap. So that's a distinction to watch out for the exempt versus non-exempt.
Is there also, if I'm not mistaken, Terah, rules related to furloughing that it needs to be concurrent over a period and not intermittent? Is there a potential to violate a furlough status by doing the week on, week off, just in general?
I'm not aware of anything like that. I'm not sure if something like that has come out in new legislation that I haven't seen yet. But in general with furloughs, the things you're going to want to look out for are the things you'd want to look out for when you're making any kind of employment decision. You make sure you're, using kind of objective criteria, that you're not, treating people in protected classes differently, that kind of thing. But other than that, I haven't seen anything that would prevent people from doing kind of the people, furloughing people in shifts of, 2 weeks at a time or something like that.
Or the awareness of not violating let's call it the daily denial of pay to a exempt employee.
Right, exactly.
Versus the weekly pay. Another thing that I did notice this morning on one of the bulletins that came out just this morning on some of the clarification details was talking about some of the stuff on the Paycheck Protection Program being retroactive back to February 15th and allowing a grace period for people to bring people back onto their roles immediately, even if they had, whether we call it termination or furloughed or whatever it was they had done, to get them back on there and keep them on there until the program ends on June 20th, to make sure that people who might have made a mistake or might have made a decision without the proper information, bring them back on right away so that they can take advantage of some of the programs.
Okay, our next question is about a business where we have an owner employee, and they're asking about the payroll protection program. Does K-1 profit distributions paid to the owner employee, are those included under the definition of payroll for a PPP loan?
So I'll say I'm sure that's in there somewhere. Honestly, I have not myself seen specifically, because it's dealing mostly with payroll. And usually those distributions are coming from outside of payroll. So I honestly don't know. I would have to go back and have one of our compliance people. We have a lot of people here. We've been in the tax business before we were in this business for 40 years. So we have some really good people on tax and compliance, Joe and Jeff and Howard and these guys. And I can go check on that and get an answer back unless somebody has one that they would attest to today. But I honestly haven't seen anything. I always see the same similar language in the regs as they're coming out, where it talks about, hourly wages, cash tips, sick pay, medical leave, health insurance premiums, things like that. It doesn't say anything about, in most of the language you're saying, it doesn't reference partnership payments or distributions, things like that. Tim, Terah, have you guys seen anything definitive on that?
I have also gotten this question, and I have not seen definitive guidance come out on this yet. There's a, there's a definition of payroll cost in the CARES Act, which has, multiple subparts, but one of the subparts is that it includes salaries, commissions, and similar compensation. What is going to, fall into that similar compensation bucket? I'm not totally sure. So I anticipate that we will get guidance on that, but that to me, I think is the only place where there could potentially be an argument that, owner compensation could be covered, but hopefully we'll get an answer soon.
And on a kind of a side note to that, if you look at almost everything in the coverage, and in fact, even this, $1,200 check that's going out to people up to $75,000, and then once they make over $75,000, it phases out at $5 per $100 of pay. That basically caps out at $99,000. And then almost everything else in the provisions, when you're talking about credit for reimbursements and everything, caps out at $100,000, of salary up to $100,000. And it may be that the general tone of the legislation really is to ensure we're taking care of people that make less than the 100,000 or less than the 75,000, and that we're also making sure that if somebody is on as an owner in their company as an employee, they're going to be covered up to their $100,000, but anything beyond that would not, in theory, be covered under the Act in general. And so you'll see a lot of that $100,000 cap stuff throughout. And I see several of the questions on that. It's not if you make over $100,000, you don't get to participate. It's you only get to participate, or the company only gets to participate for up to the $100,000.
Okay, our next question is, do we need to maintain the same number of employees from now through June 30th, 2020? I assume this has something to do with eligibility for payroll protection, because in general, you don't have to maintain the same number. Who wants to take that?
So I can give kind of a rough outline of what my understanding is. These small business loans are not totally in my wheelhouse, but I mean, I have read the CARES Act and have read the guidance that has come out. So the way I understand it, and barring any further guidance we get, is that if you reduce the number of employees, or if you reduce people's salaries, as long as you correct that by June 30th, 2020, that should not impact the amount of the Payroll Protection Act loan that can be forgiven. One thing I'm unclear on is whether there would need to be any retroactive pay given to those employees in order to correct it, or if correcting it is just going to be, as of June 30th, bringing the employees back or raising their salary back to where it used to be. That's something I'm unclear about, but it does seem to offer employers some, leeway as far as if you've already made layoffs, or if you need to make layoffs now before you get funding for your Payroll Protection Act loan, the amount of time that it's going to take for you to bring your employees back if you've already taken action.
Here's a related question. If we bring people back on June 30th, 2020, are we considered in compliance with forgiveness, or should we bring them back before June 30th, 2020?
So a couple of things, I've seen the June 30th, but I've also seen a June 20th date. So on the notification that came out this morning, I know it talks about program period, covered period of the program begins retroactively February 15th and runs through June 20th of 2020. So regardless of whether it's the 2020 or the 2030, bringing them back on your rolls, remember, it's also based on what you paid them when they were on your rolls. So if they weren't on your rolls and you weren't paying them anything, what money are you, what loan are you trying to forgive, or what are you applying to that? Again, it goes back to keeping records of everything to make sure the dollars spent fall within the guidelines so that you can claim credits for the dollars. But I don't know what happens after that. I think today the provisions, the way they're written, they go through that June period. And then I imagine there will be some new notifications or extensions of those based on what's going on after that date, or as we creep up to that date. And one last thought, on the prior question, I thought I had seen that for the 100% recap on the SBA loans, you would have to maintain 100% of your employees, but that there would be kind of a pro rata recap based on the percentage of employees you kept. But I don't know what the floor on that is. If you went down to 50%, would you get nothing type thing? But I believe there is for 100% recap, it's 100% of your employees, and anything below that is kind of a declining pro rata recap. Terah, had you heard anything else about what happens after June, or are we all working from the same premise that these are things that need to happen prior to that date unless the regs are extended or change?
That's my understanding. And I mean, with the news alerts I was getting yesterday about, you know, the goal being that people could start applying for these loans on Friday, you know, I'm hopeful that we will get some additional guidance on some of these things before Friday, before people start submitting applications and these loans actually start being funded. Because, you know, it'd be kind of a tough spot to be in, to be one of the first businesses to get these loans, but to be kind of a guinea pig on how this is all going to play out. So hopefully more guidance will be forthcoming in the next 48 hours.
All right, here's another question. In cases of workforce reduction, when they say rehire and maintain the same number of employees, does it mean the same individual employee or just the numbers have to match?
I believe that's going to be one of those things that we won't know until the case comes up, but my assumption would be maintaining the same number of employees, because all businesses would have natural attrition and turnover, particularly in certain industries. You certainly wouldn't want somebody to necessarily try to manage their natural turnover. But again, I think you'd want to definitely look at that and document what it is you're doing. Make sure you check it with either your in-house counsel or have them check it with your labor attorney to make sure that there isn't some difference between it. But my assumption from the reading has been maintaining the number of hires, not always in every case the exact same employee. And Terah, do you read that differently?
That's my assumption, barring any official guidance to the contrary.
All right, our next question is, if an employee asks for paid leave on top of what was already defined in the offer letter, for example, 1 week of sick pay, 2 weeks of vacation, to take care of kids at home, does the employer need to comply and give them additional paid leave?
So the paid leave that is provided under the Families First Coronavirus Response Act is in addition to any leave that is already granted to the employee, either through existing employer policies or anything like a contractual offer or anything that was included in the offer letter. So it is on top of anything that they already get.
Okay, for a case of a husband-wife partnership, will payroll tax credit or the PPP loan rules apply?
The paycheck protection applies to your employees, not to families, not to spouses. It's designed for your employees. So if only one of them's working for you, only one of them would be part of the keeping them on your payroll. Because remember, you're getting a credit for the amount of money you're spending on the payroll. So if the question is the husband and wife partnership, are we talking about they're a husband and wife that own the business in a partnership?
Yes, I think the question is asking, say they're like a limited liability partnership owned by a husband and wife. Do the payroll tax credit or the PPP loan rules apply in that situation?
I would imagine it would be based on whether or not they are paying themselves through the company. or whether they are taking partnership payments on the outside like a K-1 similar to before. I think they definitely want to check with their attorney or their tax preparer for that, because most of this is based on what's paid through payroll processes. And as Terah mentioned earlier, there are some you dig 3-4 levels deep into some of these definitions, and there may be something in there, but I've not read anything that talks about reimbursing people for K-1 payments. And I would assume that this would be the same case, unless as an employee, while they may be a partner, is also an employee if they're doing something through payroll.
All right, our next question is, what is your personal opinion on forgiveness? Do you think if a business retains all employees, forgiveness is probable? What about natural attrition, which I think you've discussed prior? But do you think that businesses who keep their employees will be eligible for forgiveness?
Yeah, I think, again, this is a personal opinion because the regs say that's what's going to happen. But again, until people file for it, until they actually receive a check, we'll never know for sure. But the money's already been allocated in the budget for this. So it's not like people are going to apply for a credit and we're going to see if the money's there. The $2 trillion as part of this program has already been laid out. That $349 billion for the paycheck protection under these SBA loans is already there. The money for the paid leave under the FMLA expansion is already there. The money's already been budgeted, allocated for this purpose. I don't understand why it wouldn't be. I think if it isn't, it's probably going to be because people didn't take care to provide the accurate coding through their payroll systems or leave systems, or they don't have the right reporting or backup documentation when they actually make the claim or when they're audited based on the claim.
All right, well, we are now reaching 11 o'clock, which is going to be the conclusion of our webinar. I want to thank our panelists so much for providing their expert analysis on these challenging and changing laws and times that we are living in. I also want to remind everyone that the information presented was to the best of our present knowledge, but please note that the circumstances and the law are rapidly changing. Please consult with your legal counsel and financial experts regarding your particular circumstances. None of this information was intended as legal advice. And thank you so much for your participation. I want to remind you that the U.S.-India Chamber of Commerce is online. You can check us out on our website to learn more about us at www.usicoc.org. Thank you so much.
Thank you, everyone.
Thank you.
Thank you.
Thanks, everybody.